The Parliament Acts 1911 and 1949. The House of Lords' authority to reject a bill is restricted by the 1911 and 1949 Parliament amendments. They require a bill to become legislation even if it is disproved by the House of Lords, so that the legislation is reintroduced in Parliament's next session and meets all the steps there again. The idea behind the Parliament Acts is that the House of Lords is not an elected government, and its role is to amend and contribute to the legislation rather than to challenge the will of the House of Commons, directly chosen. In addition, when this method was used to circumvent the House of Lords after it decided against an act, there were only 4 times. The Parliament Acts have only been used on 4 occasions since 1949. These were for the following: War Crimes Act 1991, European Parliamentary Elections Act 1999, Sexual Offences Amendment Act 2000, Hunting Act of 2004. These 4 acts are important. Remember them. 12. Commencement of an act. After the royal assent, Parliament's act would usually be enacted on the same day at midnight if no other date has been set. There has, indeed, been a rising trend not to enact Parliament's acts right away. Alternatively, the act itself points out the day when it begins or transfers duty to the specific minister to set the date of enactment. In the latter situation, by giving a starting order, the minister can put the act into effect. This can trigger confusion issues as it is difficult to find out which parts of the law have come into force. The 2003 Criminal Justice Act is a perfect example of legislation in which the provisions were enacted in parts. The 2003 Criminal Justice Act contained 339 sections and several schedules. The section for the enactment of the act is as 336. It said that parts of 11 sections, out of a total of 339, enter into force promptly after the royal assent was achieved by the act. This was on November 19, 2003. Most of the provisions that came into force instantly were of a procedural nature, enabling, for example, the appropriate minister to establish rules ready for the enforcement of parts of the act. The enactment section then said that 4 weeks after the royal assent, SS 269 to 277 would come into force. These sections deal with the effects of life imprisonment and how long prison sentences have to be executed. It entered into force on December 18, 2003. The starting clause called for all other provisions to come into effect when an order was issued for the enactment by the appropriate minister. As a rule, in January 2004, several provisions came into force, others in February 2004, and others in April 2004, etc. Schedule 3, which included the shift of certain proceedings from the jurisdiction of the magistrates to the Crown Court, finally came into force in 2012. Several sections, or even a whole act, might not become law ever. An instance of this is the 1928 Easter Act, which was meant to set the Easter Day date. While this act passed all the requisite legislative stages and the royal assent was given, it never came into force. One can see that it generally takes a few months to pass a bill with all these stages. There have been times when all sides have agreed that a new law is promptly needed, and a law was passed in less than 24 hours. This occurred in 1972 with the Northern Ireland Act. There may be a date set for the commencement, or the appropriate minister can enact on the date he sees fit. Example of an act. It will be useful in paper too. This part will not be assessed, however. You should know to make a clear distinction on how an act is read and how technical it is. If you have time, you can assess this part when critiquing the Acts of Parliament about the language used and how it is tough for the people to understand. The Act's name is given under the Royal Coat of Arms instantly. 1996 Chapter 19 foot under the name implies that it was the 19th Act to be enacted in 1996. A short statement or preamble on the intent of the Act occurs next. Then there is a formal declaration stating that both Houses of Parliament have approved the Act and have obtained the royal assent. This is included in both Acts. The rest of the Act, laid out in part, follows after this. This is an exceptionally short Act as it has just 3 parts. Section 1 abolishes the law of year and day. Note in those terms, and the Act refers to it, because the rule was part of common law and was never published in any statute. Section 2 determines when the Attorney General's approval is necessary before a trial can begin. The last clause provides the term by which the Act can be referred, and it also notes that the Act does not refer to situations in which the events that led to death occurred prior to the passage of the Act. Section 3 deals with the introduction of the Act, which sets the starting date for S2 at 2 months following the passage of the Act. Although S1 is not specifically mentioned, this section applies to the normal rule that a statute comes into effect at midnight of the day on which it receives the royal assent. Criticisms of the legislative process. There are many complaints about the legislative process. In addition, the Renton Committee on the Preparation of Legislation, which published in 1975, found out that there had been opposition for decades. Citing Edward VI as stating more than 400 years ago, "I would like the unnecessary and cumbersome laws to be put together in one number, and made more clear and concise, in order for men to understand them better." The Renton Committee said there were 4 main categories of complaint. In many acts, the vocabulary used was vague and ambiguous. Acts were over-elaborate as draftsmen were trying to take care of every risk. Despite parts seeming to be out of order, the internal structure of many acts became illogical, making it harder for people to find appropriate sections. There was a lack of a clear link between acts, so locating all the acts on a given subject was not easy. Furthermore, the repeated custom of modifying small parts of one act while introducing another has made it more difficult to figure out what the legislation was. 81 proposals were provided by the committee, but only about half of them were put into effect. Very important for the analysis. Lack of accessibility. Preferably, land laws should be readily available to people, but there are a few major issues that cause complexities not only for ordinary citizens but also for attorneys and even for the Lord Chancellor in some situations. As already stated, it is difficult to find out which actions have been put into action and/or which parts. An indication of difficulties of understanding what provisions are in place is the 2003 Criminal Justice Act, which has 339 parts with several plans. When the royal assent was granted, just 11 pieces came into force. 4 weeks after the royal assent, some more entered into force. Most of the other 300-plus pieces over a number of years or not at all have been put into effect many times. In actuality, S43 was never managed to bring into effect when it came to keeping fraud trials without a jury and was repealed in 2012. When provisions come into force at different points in time, it's hard to know what the statute is. It prohibits easy access to the rules. Internet research. Consider the section or timetable for the outset in a current Parliament Act. This can be done by looking at www.legislation.gov.uk for a printed copy of a statute in a library or on the Internet. Usually, there is a list of provisions at the beginning of an act. Other problem. Most laws are modified by subsequent legislation in order to make sense of rules, and it is necessary to read 2 or more actions together at times. Delegated laws may also apply to the law in the context of legislative instruments. All of this makes it more difficult to find the legislation that is currently in place. The vocabulary used in acts is often not clearly understood, and this means, apart from the usual challenges, other cases go to court as well. In addition, nearly 75% of cases considered each year by the House of Lords in its judicial role include disagreements over the application of laws. In 1992, under Lord Ripon, the work of a Hansard Society Commission outlined 5 concepts of democratic lawmaking. These are the following. Laws are drawn up to help the people, and thus all citizens should be engaged in the legislative process as completely and freely as possible. Statute law must be steeped in parliamentary authority and deeply subject to democratic examination. The law of the Act should be as safe and clear as practicable. The law or the statute must be as readily accessible as possible. It is just as necessary to get the law right as to get it enacted quickly. If these recommendations were to be implemented, the consistency of the statute book would be increased. Furthermore, it is important to use codification and/or unification to make the law more available. Under this framework, all the law on one topic could be combined into one parliamentary act, rendering it both more readily available and, hopefully, more understandable.